When her grandfather passed away, she thought the hardest part was grieving the man who had been her father figure her entire life. She was wrong. Within days of his death, two uncles she hadn't heard from in nearly a decade showed up. Not to mourn, not to comfort the family, but to chase down a debt they claim she owes. And they want every single penny back. So today we're asking the question, when your loved one gives you money before they die, and someone else comes knocking after they're gone, do you actually have to pay it back? The answer might surprise you. Let's set the scene. Our storyteller, we'll call her the granddaughter, grew up with her grandfather playing the role of her father in nearly every meaningful way. He taught her how to drive. He walked her down the aisle at her wedding. She lived in his home for months at a time during her childhood and teenage years. This wasn't a distant relative. This was the man who showed up consistently for the big moments and the small ones alike. A couple of years ago, the granddaughter moved from Arizona to Texas with her husband. Like a lot of young couples, they were trying to get ahead financially, but found themselves stuck in that frustrating in-between space, wanting to buy a house, but carrying debt that made it difficult to qualify. Her grandfather, who had also helped her younger sister purchase a home, wanted to do the same for her. Because that's what he did. He showed up. So he gave her $10,000 toward a down payment. When the debt on their car payments made that amount insufficient to qualify for the loan, he gave them another $10,000 on top of that. $20,000 total. And here's where it gets nuanced and legally important. Her grandfather sat her down and told her she could pay him back $100 a month on the first of each month with no interest, and that when he passed away, she should stop paying entirely. He wasn't expecting the full amount back. He made that explicitly clear. Now, the granddaughter admits she brushed past that conversation. She didn't want to sit with the idea of her grandfather dying someday. She dismissed it, the way you do when someone you love is still healthy and present, and the thought of losing them feels too far away to hold. But he said what he said. And critically, when the mortgage lender asked where the down payment money came from, because lenders always ask, her grandfather sent the mortgage company a signed written document stating that the money was a gift. Not a loan, a gift. Fast forward a few months to November. Her grandfather gets sick. Doctors tell him he has somewhere between 1 and 1.5 years left. He doesn't get that time. He passes away about 6 months after the diagnosis. Suddenly and devastatingly, the man who had been her foundation is gone. And then the uncles arrive. 2 of them, driving down to Arizona under the stated purpose of helping their mother, the granddaughter's grandmother, after the loss. These are men she hasn't seen or spoken to in roughly 10 years. No birthday calls, no Christmas messages, no congratulations when she got married. Silence for a decade. But now, suddenly, they're present, and they're going through the finances. They find a piece of paper. It appears to be a note her grandfather wrote to himself. Something along the lines of her name, $100 per month, no interest, $10,000. Based on that single handwritten note, the uncles decide that this is a debt owed to the estate, and they begin pressuring the granddaughter to resume monthly payments. Payments that, according to her grandfather's own explicit instructions, were supposed to stop the moment he died. To add another layer to all of this, while this pressure campaign is happening, the uncles are also busy selling her grandfather's personal belongings on Facebook Marketplace. They're clearly focused on the estate's financial value, and their frustration isn't subtle. They've made it known that they're angry their own children received nothing from their grandfather, despite the fact that by all accounts, those children never called, never visited, and maintained the same decade-long absence as their fathers. So the granddaughter is left grieving, angry, and asking a very reasonable question. Legally, do I actually owe these men anything? Let's break this down from a legal standpoint, because this is genuinely interesting territory, and the answer matters. First, the signed gift letter. This is the single most important piece of documentation in this entire situation. When her grandfather wrote and signed a document for the mortgage lender explicitly stating that the $20,000 was a gift, not a loan, he created a legal record. Gift letters used in real estate transactions are formal documents. They're submitted to financial institutions. They carry legal weight. In that document, her grandfather represented to a lender that there was no expectation of repayment. That's significant. Second, let's talk about verbal agreements and whether they're enforceable. In most states, including both Arizona and Texas, a verbal agreement can technically be a contract, but enforcing it requires proof that all the elements of a contract existed. That means offer, acceptance, and consideration. Here's the problem for the uncles. Even if you accept that there was a verbal repayment agreement, her grandfather explicitly told her that payments would stop upon his death. The agreement, as described, had a built-in termination clause, his passing. So even if the uncles could somehow argue that a verbal loan agreement existed, the terms of that agreement meant it ended the moment he died. Third, and this is crucial, the uncles are not parties to any agreement here. They weren't part of the original conversation. They weren't named in any document. A debt, if it even was a debt, which the gift letter complicates significantly, would belong to the estate, not to individual family members acting on their own authority. If the estate wanted to pursue repayment, it would need to go through proper legal channels, a probate court, an executor, a formal demand. Two uncles calling and sending messages does not constitute a legal obligation to pay. Fourth, the note they found. A handwritten note that says a name, an amount, and monthly payment terms is not a promissory note. It's not a signed agreement. The granddaughter and her husband never signed anything. Without a signed written agreement from both parties, enforcing a loan of this size in court would be extremely difficult. Courts in most jurisdictions require written documentation for loans above a certain threshold, and $20,000 almost certainly clears that threshold under the statute of frauds in both Texas and Arizona. So what should someone in this situation actually do? A few things. Preserve every document you have. That signed gift letter from the mortgage company is gold. Keep it. Store copies in multiple places. If the estate or anyone acting on behalf of the estate ever sent a formal written demand, keep that too. Do not make any payments. This is critical. Making even a single payment could be interpreted as acknowledgement of a debt, which can actually work against you legally. If there is no signed agreement, if the gift letter exists, and if the terms of any verbal understanding included a death-triggered termination, paying anything could muddy the waters. Consult a probate attorney in Texas, which is where the granddaughter lives and where she would be sued if it came to that. An initial consultation is often free or low cost, and an attorney can send a formal response letter that shuts down informal pressure campaigns quickly. Sometimes all it takes is a letter from a lawyer to make people realize they have no actual case. Don't engage in emotional arguments with the uncles. They're grieving, they're frustrated, and they feel like their own families were passed over. That's their problem to work through, not a legal obligation for her to resolve. Keep any communication factual and brief, or stop communicating entirely and let a lawyer do the talking. And finally, if there's a lesson to take away from this story beyond the legal specifics, it's this. Document financial agreements with family, even when it feels uncomfortable or overly formal. The granddaughter's grandfather had good intentions. He was generous and loving. But because the arrangement wasn't documented clearly, because the conversation about what happened after death wasn't written down, she's now having to fight for something that was freely given to her by the person she loved most. A simple signed letter between them, or even a text message spelling out the terms, could have prevented all of this. Fortunately, she has something powerful working in her favor. A signed gift letter submitted to a mortgage lender. That document is almost certainly going to be the thing that protects her if this ever goes further. But not everyone is that lucky. If you've ever received money from a family member, or if you're planning to give money to someone you love, take the extra 10 minutes to write it down, sign it, be clear about what happens if circumstances change. Future you, or future them, will be grateful. If this happened to you, if a family member passed away and someone is now claiming you owe money you were told was a gift, talk to a probate attorney in your state before you do anything else. Don't panic. and don't let emotional pressure substitute for actual legal obligation. You have more protection than you might think. And if you found this breakdown helpful, subscribe so you don't miss the next one. New legal stories, real situations, and the answers you actually need, right here, every week.